Okay. Hey everyone. It's noon now. I think we might still have some stragglers coming in. This is Jackson Nichols. I will be your host today on how to get paid. I just wanted to, allow a couple more minutes for some stragglers to join us. So we'll just get started in a minute or two. Okay. Good afternoon. Thank you for joining us today for How to Get Paid, Tips and Tricks for Construction Companies in DC, Maryland, and Virginia. I hope everyone's March Madness brackets are doing well. My name is Jackson Nichols. I'm an attorney with Cohen Seglias' Construction Group. I am based in our DC office, and I advise general contractors, subcontractors, sureties, owners, and other construction industry entities in navigating complex disputes. If you guys have any questions during the program, you'll actually see there's a question section of your GoToWebinar panel. We'll try to address them at the end as time permitting, but go ahead and feel free if you see something occurs to me, you can go ahead and type it in. I'll try to get to them at the end. If I'm not able to get to them at the end, I'll be sure to follow up with you by email. You'll have my contact information provided as well. Okay, our topics today, we're going to mainly focus on mechanics liens because there's quite a bit of material to cover there. We're also going to discuss bonding claims and prompt pay statutes. And we will be focusing on the jurisdictions of DC, Maryland, and Virginia. Getting paid. All right, so payment techniques. If you're not getting paid on a job, obviously you guys are always you want to try to work things out as well as you can without having to go to the courts or anything. But sometimes that doesn't work. There's other considerations that hold things up. Your standard practices are probably to ask nicely, though we always say you want to make a record, put things in writing, whether you're following up by email or a letter. Another thing you can do is you can send a demand letter, which is a more formal notice that says you haven't paid us, this is what we're owed for, and we need to get paid. And then, if things really escalate or you're really not getting heard, you can always file a lawsuit. But outside of those techniques you might be a little more familiar with, you've got other avenues that for the construction industry, thankfully, a lot of state legislatures have seen fit to give you an extra measure of leverage. Those are mechanics liens, which are generally available for private jobs, bond claims, which are available for public jobs, both federal and state. And then you also have prompt pay statutes, which can be an additional measure of leverage. When should you call your attorney? We like to say as soon as possible. Why do we say that? Well, it's always better to be proactive, better than reactive. You don't want to be reacting to a situation. You want to be able to strategize in advance. And if you have legal counsel involved, we've been through these. This is what we do. We've been through all this before. We can help you look around the corner. We can help avoiding a small problem turning into a big problem. And there's also a lot of different tricky deadlines that you might need to navigate. And if you wait too long, then we might not be able to help you, or you might have less tools in your toolkit as far as getting some leverage in a payment dispute. Now, some of these deadlines, particularly for mechanics liens, can actually be pretty short. I mean, we see people who come to us fairly often where they've let something drag out for 6 months, 9 months, even a year since they finished doing work on the job. And a lot of mechanics lien statutes aren't going to allow you to get a lien anymore, and then you're left with less options for doing that. Compounding the difficulty is the fact that these deadlines vary widely from state to state. A lot of them will be as short as 30 days or 90 days. So you can't afford to wait too long on your payment dispute. So you're better served, if you're doing this in a bunch of different, if you're operating in a bunch of different states, you can't keep all the deadlines in your head. There's a lot of different deadlines. So we always recommend you get legal counsel involved early. It doesn't mean we have to do a lot of work, but we can just give us a heads up, give us a call. We can work through things with you and help you craft a strategy to make sure you get paid on time. A word about demand letters. These don't have to be from your attorney. They could be from you. Sometimes what we'll do is with a demand letter, we might actually we'll ghostwrite the letter. We'll draft it for you, but it'll be on your letterhead. But we're just making sure that we want to check all the boxes as far as some of the things that you have to document. Generally, you want to show that the claim was asserted. You want to make sure you comply with all contractual notice provisions. We can take a look at the contract and make sure of that. You want to make sure that you generally preserve your claim. You've got to be aware of what the requirements are for doing that. How much backup do you need to provide, for instance? Do you need to provide an actual claim amount? That can vary from state to state and from contract to contract. And another advantage of providing a demand letter, if you're later in court, it shows that you tried to work things out. You didn't just charge into court right away and say, this guy isn't paying me, it's been 20 days, I'm filing a breach of contract lawsuit. Courts want to see that people are being reasonable business people. And if you do a demand letter, you kind of go through the negotiation process with the company that you're dealing with, that you need to get paid by. Courts like to see that. And it can potentially get the other side boxed in by making them look unreasonable because you did all the steps that reasonable business people are expected to do along the way. Okay, so mechanics liens, let's jump right in. Generally, mechanics liens are for private jobs only. You don't get them for public jobs. You don't get them for federal jobs. You don't get them for state jobs. These are reserved for private jobs. And they come with a big upside of leverage. When you file a lien, you're filing a lien usually on the property. It could be on the lease if it's a tenant situation. But this gets the owner or the tenant's attention, even if you don't necessarily have a contract with them. You might be a subcontractor that's doing work for a GC, so you never have much exposure or face time with the owner. But now all of a sudden, you've liened their property or if they're a tenant, their lease, and you've gotten their attention, because the ultimate remedy of a mechanics lien, which is pretty extraordinary, is that you can sell the property in order to pay you. This will almost never happen, of course, because no owner is ever going to let that happen. But I mean, just by way of example, I had a claim for a GC that had done some work on a restaurant build out for, it was a restaurant that was, fairly small within the property it was part of. It was part of this very large, almost full block building in DC. That building was worth over $300 million. And the claim was, a few $100,000. And the remedy there to pay that $300,000 claim, if you were to go all the way through all the steps of filing the lien and enforcing the lien and closing, you would be selling the property in order to pay that. It's not going to happen, and it's a good way of getting their attention because they're not going to want to let that happen. So that gets all the interested parties involved. It creates more interested parties. It gives you leverage so that you can make sure that you're heard and that your payment claim is resolved. So it's an extraordinary remedy. The downside is liens are not easy to get. There's a lot of tricky deadlines. Different states have different rules. There's not just one deadline. There's several for just about every state. And it's, for the most part, it's one strike and you're out. If you miss one of your deadlines, you might have 3 deadlines that you have to meet. You miss one of them, your lien's not valid anymore. If you, in some states, if you overstate the amount of your lien, then your lien's not valid. There's so many different pitfalls. And they've done this on purpose. The state legislatures have set it up so that it's not, you can't just be anyone that just like marches into court and tries to get a lien or just files a lien on a property. They want to make it hard to do because the remedy is so extraordinary. So there's a lot of hoops you got to jump through is the downside, but the upside is it is real leverage that you can get. Now in DC, who can get a lien? Well, DC allows just general contractors and subcontractors. As far as jurisdictions go, it's fairly limited. If you're a subcontractor or a supplier, unless you somehow have a contract directly with the GC or the owner, you don't have lien rights. If you're an architect or design professional, that's actually an open question in DC. I've seen commentary going both ways on that, but the courts have not weighed in DC on that yet. So it's a little uncertain. The main requirement, other than being a GC or a sub, is that you have to supply labor and or materials to a construction job. That's what you have to show, and then you have to be able to show the amount of the labor and materials that you provided. I have seen the DC Recorder of Deeds say that there's a physical labor requirement. Now that's a little problematic if you're a construction manager or a GC that's, just kind of coordinating the trades and managing the work without doing any actual hands-on labor. Now, practically speaking, you probably have some that you point to, but you might not be self-performing any work. This is kind of an extra statutory thing that the DC Recorder of Deeds has imposed. I don't think it's right, but there's no reason to give them you shouldn't give them a reason to ding you on it. So I always say you want to make sure that when you provide a description of your labor and materials in your lien notice, you want to describe any physical labor at all that you can fit in there. One of the big defenses that's pretty standard is the defense of payment. This is a defense available to the owner. It is available in DC. That means that if a subcontractor or supplier is owed money and the owner has already paid the GC before they receive for that work, before they receive notice of the lien, the owner is actually off the hook for that. So if you wait too long to provide your lien notice to the owner, then you don't have lien rights anymore because they've already paid for that and they don't have to pay twice. So the takeaway from that is do not wait until the deadline. Sure, you've got 90-day deadline, whatever, to file your lien notice, but don't wait until day 89 to do that. Do it as soon as possible. Get your claim in early. Don't have to wait until the project is done, because if you wait, you might lose your lien rights because something else is happening behind the scenes that you don't know about. Now, DC, the first step, it's usually a multi-step process. Generally, there has to be notice, and then there has to be some kind of a complaint filed. That's pretty standard across different jurisdictions, but with different wrinkles. DC requires you, as your first step, in order to establish a mechanics lien, you've got to file a notice of mechanics lien in DC's Recorder of Deeds office, and it has to be done within 90 days of completion of all work on the project or termination of the project. Now, if you finish your project early and you're still not getting paid, you might still want to go ahead, and you don't want to wait necessarily that long, but that's your drop-dead deadline. After you file that notice of lien with the Land Records Office, the Recorder of Deeds office, you have to serve a copy on the owner within 5 business days of that filing. And the form for this filing is provided on the DCRA website. You can download it from there. It's pretty easy to find. And of course, we have a copy as well if you need one. Before you file, you need to do a bit of due diligence. You're going to need to be ready to have a description of the work. As I mentioned earlier, because of a quirk of the DC Recorder of Deeds office, they've provided their own little spin on things that I don't know it would hold up in court, but you don't want to try them on that. Include a physical labor description if you can. Another thing that you want to do, you have to put in the pre-filing notice a description of the property. this has to be a legally valid description. The best way to make sure that your description is viable is to do a title search for the property itself. Because if the description of the property is not accurate, then your lien might be declared no good. Another thing you need to decide as you're doing your due diligence is what exactly are you liening? If you're doing work for a tenant, say it's a build out for a restaurant or a retail store or something like that, well, you might not have the right to actually lien the property, but you do have a right to lien the lease itself. Now that's not nothing, that's still leverage. The tenant is kind of the owner in that situation, and they don't want to see a lien filed by a subcontractor or a GC. And they probably have some requirement in their lease contract with the actual owner that says that no liens can be filed and they have to clear them off right away. So you're still going to get their attention. Ultimately, you could own the lease to that property if you were to go all the way down the line. But this is more about creating leverage than ultimately foreclosing on a lease or foreclosing on a property. Now, if say you're doing work for a tenant, it's still possible for you to actually do a lien on the property, and you could even lien both. But you're going to have to be able to show, in order to get a lien on the property, you have to show that the property owner actually directly authorized the work that was being done. Another thing you need to make sure, if you're filing a lien in DC, you've got to be licensed to do business in DC. There's a special license that you have to get if you're a general contractor in DC. Otherwise, you just need a basic business license if you're a subcontractor. And you can get that pretty easily on the DCRA website. There's a few steps you got to go through, but it wouldn't be hard for you to do that on your own. We're, of course, happy to help you if you have any questions about that too. So the second step after you filed your notice of lien with the Land Records Office is you have to file a petition to enforce the lien. This is a complaint. This is a lawsuit that you have to file in DC Superior Court. And you've got to do it. You've got a 180-day time limit to do that from the date that you recorded your lien. You filed your lien with the DC Land Records Office. You're also, within a few days of filing that complaint, you're also going to need to record what's called a lis pendens on the property. This is basically a formal legal notice that the property is now encumbered by a lien that has a lawsuit pending. If you don't meet this deadline, either of these deadlines, then your lien is no good. So if you say you file your land records notice of lien claim and you serve it on the owner within 90 days, you do all that, but you wait too long and you don't file your lawsuit, you've lost your lien rights. So advantages of DC relative to other jurisdictions. One is that the lien is this is a legal term called inchoate. That means that it does not have to be enforced to be perfected. Once you file the lien amount actually relates back to the date that you first started doing work on the project. This can become a big deal later on if there's multiple claims on a property. You've got some kind of the bank might have a claim to it, some equitable claim. There might be a deed of trust. There might be other lien claimants. The first date that you get in there is important. You want to have priority on that if things get that far. Another advantage of DC is that the lien survives sale or foreclosure of the property by an inferior lien if you get in there first. Another advantage relative to Maryland, say, is that any kind of repair or improvement to property gives you lien rights. Maryland actually has a 15% rule or a 15-25% rule where you have to improve the value of the property a certain amount with the project. Another advantage of DC is that if you're a subcontractor, the general contractor actually cannot waive your lien rights in its contract with the owner. So the GC can't put in there in its contract with the owner, I waive all lien rights of my subs. That doesn't fly in DC. They don't allow that. Disadvantages of DC. DC is fairly tight with who gets to have a lien. There's no liens for remote contractors, so subcontractors or suppliers who have a contract with just a subcontractor don't get lien rights. You've got to have a contract with either the owner or the GC on the project. And then, of course, it's unclear whether or not architects or design professionals get one. This basically means that you've got to deal directly with the owner or the GC to have any kind of lien rights. Now, I said that the GC can't waive your right to have a lien if you're a subcontractor in the GC's contract with the owner, but DC does allow you to waive your rights by contract. So let's say you're a subcontractor who signs a construction contract with the general contractor. If the GC includes a clause in there that says you waive all lien rights and you sign it, you waive all lien rights. So you've got to be careful about looking out for things like that, because some jurisdictions let you do that, others do not. Okay, Maryland. Maryland is unique in some ways. It's a little trickier than DC as far as the timing components, and it has kind of a different set of pluses and minuses. The first thing you got to do for a mechanics lien in Maryland is you've got to provide notice, unless you're a general contractor. General contractors don't have a notice requirement. They just have to file their lawsuit because they're already interfacing with the owner directly. If you're a subcontractor or supplier, you're required to serve a notice of your lien claim within 120 days of the last day that you did work. What does that mean, the last day that you did work? Or it could be, if you've got a supply contract, it's the last day that you provided materials to a project. It's really going to be, you want to take that from work that is substantial and new work. Warranty work, for instance, is not going to count. If you're doing repair work, that might fall under warranty work, and that might get you in trouble. If you come back after the project's done and you're just kind of touching up some things, that's not going to necessarily extend your time for you to file a notice. If you have one contract or a continuing contract, the deadline can be extended by later deliveries ordered by the owner, for instance. But if you've got a purchase order, POs usually count as separate contracts, so each one is a contract with its own deadline. There's a statutory form that's provided for the notice, so this notice has to have certain items in it. For instance, it has to accurately describe the building and the property, and that can be done with a mailing address in Maryland. It has to accurately identify who the owner of the project is, and it has to accurately identify the work done or the materials furnished and when that work was furnished. Step 2 in Maryland is you have to file a petition to establish a mechanics lien. Just like with DC, this is a lawsuit that you have to file with the court, and this is going to be the court in the county where the work was done. You have to file it within 180 days of the last work that was done on the project. Now, what's important with Maryland, which is a weird feature of Maryland, is that your lien is actually not valid at this point. You provided the notice, you filed your lawsuit, you still don't technically have a valid lien. So that's different from DC. If you'll recall, we just discussed with DC, you have a valid lien when you file that notice of lien, and it gets dated back to when you first started doing work. Maryland doesn't work that way. Maryland says you have to go and appear at what's called a show cause hearing, and that gets scheduled after you file your enforcement complaint. The show cause hearing is like a mini trial. It's not a final trial. It's not a final ruling on the merits of your lien. It's an initial ruling that's kind of a provisional merit on the provisional merits of your lien that says, you know what, there's enough here that suggests there is some validity to this lien claim as far as the amount. They got everything done in time. So this kind of looks like a valid lien claim. The other side's not going to be able to dispute a lot of things in there as long as you're able to prove it in some way. They might have a bunch of back charges that they want to say zero out your payment dispute or your payment claim. Well, this isn't the time for them to really do that. And so once you have that initial show cause hearing, you'll hopefully be able to get a ruling from the judge that says this lien appears valid, and they'll grant you what's called an interlocutory lien. The nice thing, and at that point, you have a valid lien, but you're not able to enforce it until you go through and finish things out. Sometimes at that initial show cause hearing, you might be able to get a ruling on a final lien claim, but that would be a little more rare. Now, the show cause hearing, the nice thing about it is that courts will generally schedule it pretty quickly. They're supposed to schedule it within 90 days of filing your complaint to enforce the lien. So, the downside of Maryland is that your lien isn't considered valid until that date that you get that ruling, but at least you get to go into court right away, a little bit quicker than you would with standard litigation complaint that you have to file. Usually, if any of you have ever had to go through litigation before, you know that the timelines for that can be very spread out, protracted, and it can take you a while to actually even get before a judge after you filed a lawsuit. Maryland will at least allow you to get into court in front of a judge and say, hey, I've got a valid lien claim. We'll fight the fight of some of the disputes about the other stuff, but the basic facts are established. Now, Maryland distinguishes between a petition to establish and a petition to enforce your mechanics lien, but as a practical matter, you should always just do both together. The contents that are required for the petition, this again is your lawsuit, that you're filing to enforce your lien. You need to have the name and address of you, the petitioner. You need to have the name and address of the owner, and you need to have a description of work and the kind and amount of materials that are furnished. You also have to say when that work was done, because they're trying to make an initial evaluation of have you checked all the boxes that you have a valid lien claim. Additional things you got to have: the amount claimed to be due, description of the land adequate to identify the building. Again, I recommend you do a title search. There are public records that you can look up in Maryland, or your attorney can look up on their own, but it's usually better to sign off on a title search just to make sure, because it's important that you meet all the requirements. You check all the boxes when you get these things in. There's also, if there's multiple parcels involved, you have different work that's done on perhaps in a subdivision, you have to actually allocate the claim between that. That gets into a whole other can of worms that we're not going to get into here, but it's another complication that you have to deal with mechanics lien, just another hoop you got to jump through. You have to provide an affidavit that's setting forth facts to establish your lien. When you file something in court, if there's going to be a presumption that the facts are valid, you have to have a witness testify to that. And you can do that. They don't have to come into court necessarily to say it, but you need to be able to sign a document that says that's what an affidavit is. It's someone with knowledge of the actual factual subject matter who says, this is true, I'm saying under penalty of perjury that all these facts are valid based on my experience. And then you want to also include with your petition originals or copies of all documents that establish the lien. Lien waivers. So we talked about this in D.C. D.C. will allow you to waive your lien rights in a contract if you're a subcontractor or a GC. Your contract with the construction contract itself. Maryland does not allow that. That is considered void as against public policy. So you can't actually do that. So maybe you missed that when you were doing your contract review. You're probably okay in Maryland because Maryland usually doesn't allow that. But you can still waive it in a separate document outside of the construction contract. And where we usually see this come up in the construction industry is with partial payment claim waivers or lien waivers. You're probably all familiar with this. It's a very common practice in the construction industry. Every month you get in your pay app and they require, whoever's supposed to pay you requires you to sign one of these waivers. And the language of these can be very tricky and it can be very different. And some of them will actually provide that you're waiving not just claims for the work that you've already done, as you might think you would be doing, but some of them might say you waive any lien rights going forward. And Maryland is among the jurisdictions that might allow that to happen. So you got to be careful when you're looking at those, those monthly pay apps and those lien waivers that they give you with that. Some unique features to Maryland, or just kind of specifics as far as what you can lien. Maryland allows you to lien every building. That includes, it's a pretty broad definition, wharfs, bridges, certain utilities, anything that's erected or repaired, improved or rebuilt. If it is not new construction, then it has to be rebuilt or improved by a certain percentage of its value. If you're doing work for the owner, it has to be 15% of its value. If it's work for a tenant, it's got to be for 25% of the value of the property. Now, that's not just for, let's say you're a subcontractor, that's not just for your scope of work. That's for the whole project. The whole project has to improve it by a certain percentage amount of the entire property's value. Maryland, unlike DC, does not have an affirmative defense of payment. That means that a lower tier sub can lien work for which the owner has already paid the general contractor. There's no defense of payment by the owner. They can't say, well, I already paid the GC. That doesn't invalidate your lien. And that's kind of necessary in Maryland when you think about it, because you have to wait so long to get into court for the show cause hearing to begin with. We just went over the show cause hearing. Upside is it allows you to get a lien hearing relatively early to establish validity. Litigation over factual issues still proceeds after that, but the nice thing is it does let you get in fairly early. Downside is your lien rights do not date back to when you actually did the work like they do in DC. Maryland has some significant disadvantages. A sale of the property before the lien validity is established, that is, before you get to that show cause hearing, can actually destroy your lien rights. So that's a big downside. And, again, it just goes to show, fortune favors the bold. You want to make sure you get in there and check all your boxes for your lien claim early and not wait too long. You want to allow some time to work things out because it's better than trying to go all the way down the line into court. That can be costly. You don't want to have to do that all the time, but you do have to be careful of waiting too long because you don't want to destroy your lien rights by allowing something like a sale of the property, or another one is that if the owner of the property files for bankruptcy before your lien validity has been established, that would also destroy your lien rights. Another disadvantage, a Maryland lien is inferior. That means it has lower priority to a construction loan, deed of trust, a judgment lien, or anything else that is recorded in land records. Maryland just doesn't give higher priority like that. And like I said, priority in Maryland does not relate back to the date that work began. Virginia is a really tricky jurisdiction, in my opinion, because it has an extra layer of deadlines that make you have to think about things a little bit differently. I always recommend that you engage legal counsel to deal with mechanics liens, because it's one strike and you're out, and there's a lot of boxes that you have to check. Virginia has some additional boxes, and you really want to have someone, and not just an attorney, frankly, you want to have a construction attorney that's got experience with dealing with Virginia liens. The nice things about Virginia, though, is that once you establish the liens do have high priority over other property interests, including foreclosure sales and bankruptcy. Another nice thing about Virginia, it does allow anyone in the contract chain of labor materials to have lien rights. Are you a third-tier contractor? You get a lien. Are you a second-tier supplier? Yes, you get a lien. Are you an architect or design professional? You get a lien as long as you have provided labor materials to the property. Virginia, like DC, has a defense of payment defense for the owner. Again, that means that if a subcontractor supplier is owed money and they assert a lien claim, but the owner, before that lien claim was asserted, has already paid the GC before it got notice of the lien, then the owner is off the hook and you've lost your lien rights. So again, don't wait until the deadline to do it. Get your lien claim in early if you can. You don't have to wait in Virginia until the project is completed to file your lien. If you wait, you might lose your lien rights. So Virginia does the usual two-step process. Similar to DC, the deadlines are somewhat similar as far as your deadline for getting your notice in. You have to file a notice of mechanics lien in a land records office This would be, DC is centralized. There's just one recorder of deeds office. That's the land records office in DC. Virginia is decentralized, and it's going to have to be in the land records office in the county where the project, where the work was done, where the project took place. Virginia's got a 90-day deadline rule, but it's a little tricky. It's not that simple. If the project is still ongoing, it's 90 days from the last day of the month in which that lien claimant last performed labor or furnished material. So if you last did work on September 24th, you've got 90 days from September 30th to provide your to file your lien notice. But if the project ended on September 24th, then you only have 90 days from the date of completion. So there's kind of a backstop deadline for Virginia. Subcontractors and suppliers, that notice must be provided to the owner of the property after you filed your notice with the land records office. General contractors have to also take that notice and file a certification that the notice was provided. Here's where Virginia starts getting trickier. They have a 150-day rule, and they allow multiple liens to accommodate that rule. Virginia has a prescribed maximum number of days for which you can lien work. You only get up to 150 days worth of labor or material deliveries. So you can't lien for 152 days. You can't lien for 160 days. If you exceed that 150-day rule, that doesn't just mean you lop off the extra. That means it invalidates the entire lien. It's one of the hoops you got to jump through. Now, they count that 150-day time period back from the date that the last day of work was done that's described in your actual lien notice. So this is kind of like a look back deadline as opposed to a looking forward deadline. And juggling those can be a little bit tricky in Virginia. To help deal with that, Virginia does allow you to file multiple liens because you want to stack them up in roughly 150-day max chunks as you go along the way. Downside, of course, is that you're having to file a lien in the middle of a project when, hopefully you want to get along with everybody there, but Virginia does not give you much of a choice on that. As part of your due diligence, pre-filing, before you file your lien notice, what do you need to have ready? You need to have a description of the labor material supplied. You might have noticed by now this is pretty standard for all of the lien claims and lien notices. I highly recommend you do a title search of the property through a title company. We're happy to recommend some if anybody needs more information on that. The lien can be invalidated in Virginia if the property description is not accurate. Virginia is probably one of the stricter jurisdictions on the property description, so you really don't want to mess around with that. And then similar to what we discussed with DC, Virginia, can you lien the lease or you lien the property? Well, it depends on whether or not you're doing work for a tenant or an owner. If you're doing work for a tenant, you can lien the property, but only if the property only if the property owner directly authorized the actual work. Another thing in Virginia, similar to DC, you need to have a contractor's license from Virginia. If you're not licensed in Virginia and you want to do your lien claim, you have to certify that it was not required for the work done. And then there's an additional requirement for residential jobs. There's a pre-filing that you need to do before construction starts. There's something in Virginia called a mechanics lien agent. This is just an extra layer that they provide for residential jobs because it's not the same as dealing with commercial. Okay, so you filed your notice of lien claim and you've served that notice on the owner. That's step one in Virginia. Step two, just like with DC, you got to file a petition to enforce the lien. Again, this is a lawsuit that you file in court. You have to file it in the circuit court of the county in which the work was done. This has to be done within the latter of either 6 months from the date that you filed your notice of lien claim with the land records office, or it has to be 60 days from when the work on the project was completed or terminated. But it's the latter of those two deadlines that you get. Failure to meet any of these deadlines invalidates the entire lien. You'll lose your lien rights. Advantages of Virginia relative to some of the other jurisdictions. The liens, as we discussed, they have very high priority, and they go back pretty far. They relate back to the date that the labor and the material is supplied, and also the lien survives sale, foreclosure of property by an inferior lien. Big advantage Virginia has over Maryland. Another advantage that Virginia has over, say, D.C., there's no known limit on subs or suppliers. You can go all the way down the chain. You just have to be able to trace the labor and materials that you provided to the property where the work is being done. Virginia also clearly allows you to file multiple liens, and it's any repair or improvement to the property. There's no 15%, 25% rule like you have in Maryland. Disadvantage is, the time limits are complicated in Virginia. It's tough. The 150-day look-back rule, combined with the 90-day 3-month rule for filing the initial lien notice, it's tricky to juggle all those deadlines like that. Another thing with the 150-day rule that I think makes it tricky is that you've got to actually do a pretty detailed analysis of your project documentation. I mean, 150-day rule, the 150 days, that kind of matches up with your monthly payouts, but not entirely. There might be a few extra days, extra or less on there. And so you can't just stack all your payouts up and say it's all in there. You might have to do some kind of analysis of timesheets or invoices to make sure you're not claiming a lien on any kind of work that was done outside of that time frame. Another disadvantage, this is true of Virginia in general. I think of Virginia as kind of a tough toenails jurisdiction. The courts tend to be very strict with things like notice provisions or releases or waivers that you sign, particularly lien waivers. They're pretty tough to deal with on that. And, you've got the 150-day rule that can invalidate the entire lien. Courts are not going to adjust that amount up or downward. Then, of course, you've got allocation for multiple parcels. That's a complication that you have to deal with if it's like, a subdivision unit that you're doing work on multiple properties. If you don't do that right, that can invalidate the lien. Okay, that is mechanics liens in a nutshell. Again, mechanics liens are only for private projects. You don't get them for public projects. So how do you get security on a public job, whether state, federal, or otherwise? Well, there's a different mechanism for that, and that's through bond claims. The federal government has what's called the Miller Act, which gives you a right to make a claim on a bond that's held by a bond principal. That can be a general contractor. It could be a subcontractor with its own subs. They need to have a bond. Now, when we're talking about bonds, we're talking about payment bonds here. These are for Miller Act claims. And what we're actually talking about in this case are state-specific versions of the federal Miller Act. These are generally called Little Miller Acts. For the most part, each state has enacted its own state statute that allows you to make a bond claim on a public job. It's very similar to and modeled on the federal Miller Act claim. This applies to each state, city, town, county, and their agencies for any of those involved public projects. And kind of broadly speaking, it is similar to mechanics liens. It's a two-step process. First, you've got to provide notice. Sometimes you don't. And then the second step is you have to file a lawsuit to enforce your rights. Who has to provide notice? Not everybody. If you're a first-tier subcontractor who is owed money by your GC, you have a contract with them, and you actually don't have to provide notice in order to preserve your bond rights. It might be smart to do it anyway, just in case, but generally you don't have to do that. Now, if you don't have a direct contract with whoever holds the payment bond that you're making a claim on, then you are required to provide notice. What's the deadline for that notice? Generally, it has to be within 90 days of the claimant's last work. Best practice is to count that deadline from the date of last substantial and new work. So, small things, repairs, especially warranty work, is probably not going to extend your deadline. You also are going to need to state in the notice the amount of your claim with quote unquote substantial accuracy. So you want to be as precise as possible when you do that. In order to enforce your bond rights, step 2, you've got to file a lawsuit to enforce the bond. So if you were required to provide notice, you've got to do that first. The next step is to file your lawsuit that seeks to enforce those rights. And you can generally pair these with the breach of contract claim against whoever owes you the money in addition. And so you could have multiple parties there where you have the surety as well as the GC or the sub or whoever owes you money. You also have to wait. One requirement. Well, sorry. First of all, the deadline is within a year of the last work that you did, and you're also required to wait at least 90 days after that work before you can actually file your lawsuit. So you can't just say 10 days out, I haven't been paid. They've already refused to pay me. I'm going to give them notice, and then the next day I'm going to charge into court on day 12. You can't do that. You actually have to wait 90 days. The idea here being is that they want you to try to work things out, and so try to draw out the two-step process just a little bit. Bond claims, there's no defense of payment. If you're a general contractor, you got to make sure that all covered subcontractors and suppliers have been paid, just to ensure that no claims are made on your bonds. Speaking about DC, Maryland, and Virginia, that's what we're covering here today. These are actually all the same as far as the timing for those deadlines. Notice has to be received by the bond principal, say the GC, by certified or registered mail within 90 days of the claimant's last work. The lawsuit has to be filed more than 90 days after the claimant's last work, but within 1 year of the last work. Some important additional notes on bond claims. The statute provides, that you have bond rights if you provided labor material to the project, and you're entitled to be paid for that, and you have a bond claim if you've done that, and you satisfy the notice requirements. So the statutes provide that kind of minimum bundle of rights. However, the language of the bond form itself may provide additional rights than what is required by the law. Now, you might not necessarily have a copy of the bond. That's considered a no-no. You're supposed to get a copy of the bond at some point, and you should always ask for a copy. But there's ways around it if they decide not to give you a copy of the bond, and you know that you have certain rights under statute even without looking at it. But you might have some additional ones if you're able to look at the actual bond. And another wrinkle on bond claims is that second-tier materialmen, that is a supplier to a subcontractor or supplier, generally do not have bond rights, unfortunately. Prompt pay statutes. So let's say you missed your deadline for your mechanics liens on a private project or your bond claim on a public project. Well, it's not the end of the world. Of course, you still have a breach of contract claim. You still have legal rights, or you may. It's just that the deadlines for breach of contract claims tend to be longer than they are for mechanics liens and bond claims. Usually they'll range from 2 to 5 years, 3 years being a pretty standard statute of limitations period for when you need to file your lawsuit to enforce those rights. But the construction industry in a lot of states is fortunate to have, if you're someone who's trying to get paid, they're fortunate to have prompt pay statutes that the legislatures have put in place. These are state statutes that provide additional incentives to make sure that contractors are paid on time. The public policy here being that you want to make sure you ensure the health, the financial health of the construction industry. These are in addition to your right to file suit for breach of contract, and they give you some additional leverage. Some of them will give you interest, and some will even allow you to get attorney's fees for having to file a lawsuit just to get paid. DC is one such jurisdiction. It's got a private Prompt Pay Act that was enacted about 6 years ago. This provides protection to contractors, subs, where owners of GCs fail to timely pay undisputed amounts. Now, undisputed amounts is defined in the statute as an amount owed on a contract or subcontract for which there is no good faith dispute, including any retainage withheld. But what does good faith dispute mean? No one is sure because the courts have not weighed in on this yet, as far as I'm aware. I think you might be able to go by a good rule of thumb. A lot of times you'll have someone will assert back charges against you and try to zero out your claim during the negotiating phase if things come to a dispute. But if they can't zero out your claim, even with those back charges, then you've got an extra amount that there should be. I feel like there's no good faith dispute on that. That's your standard argument I think you'd make in that situation. And DC does allow you to recover both interest and attorney's fees for if you're able to win, if you bring a lawsuit and win on your Prompt Pay Act claim. This would be an additional count you would include with like a breach of contract claim. This applies to construction contracts to provide labor materials or both for demolition, building, renovation, alteration. Pretty broad statute applicable to the construction industry, basically. It applies to both work for a property owner or for tenant work. It does not apply to work for DC agencies. DC's is a private prompt pay statute only for private jobs. And because it was enacted back then, it applies to contracts entered into on or after October 1st, 2013. There's some definition of, who's a contractor, who's a subcontractor, specific days for a number of days there, depending on whether or not it is set forth in the contract itself. It's generally 7 days after that for undisputed amounts, or 15 days after the job is completed. I'm just going to skip through this since we're getting a little short on time. But again, this will be in the materials if you want to look at it, and I'm happy to answer any questions. I just wanted to skip to the penalties for failure to pay. All right, so the owner contractor, if there's a violation of the Prompt Pay Act, they were going to owe interest of 1.5% per month on any undisputed amount that's not paid on time. Another thing is that if you can show that if you sue and you win, you can show there wasn't good faith withholding of payment, then you can get cost and actual reasonable attorney's fees. Now, the general rule when you go to court in the American system, it's actually called the American rule, is that the default rule is that you do not get attorney's fees for going to court. However, the exceptions for that are generally if there's a statute like a Prompt Pay Act that says you can get attorney's fees, or it could be in the contract itself. Sometimes there'll be what's called a prevailing party provision in there, or something else that allows you to recover still. Maryland has two prompt pay statutes. One is for private projects. It does not apply to construction of single-family residences or home improvement contracts or with public contracts, but it does have a pretty broad construction industry-based definition for what it applies to. Claims can be made by contractors, subcontractors, and suppliers. It applies to all undisputed amounts owed under the terms of the contract. Payments to the GC if the contract is silent, contract with the owner. Full payment is due 30 days after the occupancy permit is granted or the owner takes possession. If the contract states payment date, then payment must be made within 7 days of that date. For subcontractors, if the contract is silent, subcontractor must be paid all undisputed amounts within 7 days after receipt of payment. No case law, just like with DC, on what is disputed in good faith. Consequences of untimely payment. Well, like DC, you can get interest and costs, and you can get attorney's fees. Maryland also allows you to get equitable relief, which would allow you to enjoin further violations. That basically means you're getting a court order saying, hey, you got to start paying these guys on time or there will be consequences. Maryland also has a public statute. I will just say that this applies to, I do want to kind of get through for time's sake, but I'll say this applies to public construction projects only, broad construction definition, not for maintenance or routine operation of an existing property. This allows claims to be made by subcontractors under state procurement contracts. It applies to all undisputed amounts. The subcontractor has to be paid undisputed amounts within 10 days of receipt of progress payments or final payments from the government. And then we're not going to get into the weeds here, but there's kind of a dispute resolution here where you notify the government unit, if you're on a public job, the government unit that is running that job, you notify them that you have not been paid, and then they start trying to work things out. And there's a multi-step process here for getting that done with pretty tight time frames. They can do things like find the contractor or subcontractor that's not paying their subcontractor. They can suspend work until payments made, or they can order that some of the amounts be placed into escrow in an interest-bearing account until the dispute is resolved. Last and certainly least is Virginia. I say this because Virginia, the Prompt Pay Act applies to public projects only. There is no private Prompt Pay Act in Virginia, unfortunately for you if you are trying to get paid on time and you're having some trouble. This Prompt Pay Act provides protection to any privately owned entity that contracts with a Virginia agency. It also protects subcontractors by requiring timely payment clauses in the subcontract. It does not provide payment protection for private projects. And then another big downside for Virginia, for this Prompt Pay Act, and this is another reason I say last but least for Virginia, you can't get attorney's fees under the statute anyway. It only applies to public jobs, and all you can get is interest on unpaid, undisputed amounts. So these are in the materials, but if you go through here, this provides the parameters for how protections need to be in the contract for timely payment of contractors and subcontractors. And then the interest clause is there, and that's interest of 1% per month for unpaid amounts that have not been withheld in accordance with statute. That is the penalty, essentially, if it's not in there, and that's the penalty for withholding improperly the undisputed amounts. You don't get attorney's fees, unfortunately. Okay, so let me just go through and see if we have any questions. Let me just throw my contact info up here if anybody wants to email me questions that I'm not able to get to. Let's see. All right. Well, I don't see any questions, so maybe that means everything was very clearly explained or you guys are hopelessly confused. But either way, please feel free to follow up with me. And you've got my email address right here on screen. And I'd be happy to answer any questions that anyone has if you want to submit them by email. Thank you very much, everyone, for joining our webinar today. I hope you found the information helpful. We'll also be circulating the slides and a link to the recording shortly, so you can keep your eye out for that email. And we're also going to make a link to the recording available on our website at cohenseglias.com. Again, feel free to contact me if you have any questions or any follow-up about anything we covered here today. Thank you very much, and I hope you all have a wonderful day.